All right, so we jump forward about 30 years, and we have a few things have happened in those 30 years. There now exists a fundamental right to marry. The civil rights movement has had some success during this process. Obviously, lots more to come. And the court that is sitting in 1965 is exceedingly more liberal than the court even in 1937 that ended substantive process and liberty of contract. And so this law, or this case, let me say, provides a mechanism for judges to really begin to rewrite our notions of what the Constitution contains. So in this particular case, a state law prohibited the use of contraceptives or counseling anyone to use contraceptives. And it also had a criminal penalty for said violation. And the defendants in this particular case were the executive director of Planned Parenthood and a doctor who had prescribed contraceptives to a married couple. And thus they were arrested and charged with a criminal violation of this law. So, the issue in this case goes beyond just whether this law is constitutional or unconstitutional. The issue extends further because you would have to say why this law is unconstitutional. The state can regulate for health reasons, and regulating in terms of what drugs can be used and cannot be used is in the purview of the state. So the issue in this case is whether this law violates our nation's notions of substantive due process, which would be to say that there exists some right that is not explicit within the Constitution that prevents states from doing this. And the answer is yes, there is. And so even though, as we've discussed numerous times, privacy is never written within the Constitution, Justice Douglas, who writes the majority for this case, says that just the right to privacy exists within the penumbra which emanates from the Bill of Rights. So we should probably discuss what a penumbra is. A penumbra is the shadow cast by an eclipse. So it's astronomical term. So when you are in the shadow that is cast in an eclipse, you are in the penumbra. Well, the argument that Justice Douglas is making is that the Bill of Rights casts a shadow, and within that shadow we can actually see that perhaps the founders intended to be there a fully fledged right to privacy. That it touches on all aspects of individuals' lives. It isn't just contained within a couple certain amendments, but it's much more holistic and much more robust. He argues, Justice Douglas, that there exists little hints at the right to privacy throughout the Bill of Rights. The right of association in the First Amendment, nor quartering soldiers during times of peace in the Third Amendment. The right to be secure in our persons, houses, papers, and effects against a reasonable search and seizures in the Fourth Amendment, and the right against self-incrimination in the Fifth Amendment. So he takes all of these and adds them together and says there exists elements of privacy in all of these things. But when we read them in conjunction with the Ninth Amendment, it should seem obvious that the founders intended there to be a much more robust and holistic right to privacy. Remember what the Ninth Amendment says, that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so the argument that Douglas and the majority in this case puts forward is that there exists elements of privacy in a number of amendments to the Bill of Rights. And reading those in conjunction with the Ninth Amendment seems to make implicit that the founders intended there to be a much more robust and complete right to privacy than just those little emanations in the Bill of Rights. And so thus, this zone of privacy is created by several fundamental rights. And so the majority carves out this right to privacy and inserts it into the Constitution as a fundamental right. And it does so without ever invoking the words, it does so by using substantive due process. Remember that this case dealt with married individuals, and the court gives some time to that. Justice Douglas says, would we allow the police to search the sacred precincts of marital bedrooms for telltale signs for use of contraceptives? The very idea is repulsive to the notion of privacy surrounding the marital relationship. So he's like, the idea is repugnant on a natural level. We don't even need to reference the Constitution. Just our very notions of decency in society say that this idea is repugnant. The majority says that the law is unconstitutional, but it never mentions substantive due process. It never invokes it. Perhaps in part because substantive due process still at this time has fallen out of vogue. And while I refer to this case as the rise or the revival of substantive due process, understand the majority opinion never absolutely uses that term. It exists nowhere in the majority opinion. It does, however, exist in the concurrences. Justice Goldberg concurs in this case, and he very explicitly says that personally based rights are protected by substantive due process. He says it out and out. So despite its fact it's not in the majority, an individual who is in the majority and writes a concurrence very clearly says that we are reading this in as a substantive due process right. In particular, Justice Goldberg contended that the Ninth Amendment pretty much was decisive in this case because it says very explicitly there exist rights that are not enumerated in the Constitution which are fundamental and must be protected from government intrusion. And the right to privacy would seem to naturally be one of those, and the right to privacy extends to the idea to right to use contraceptives. Justice Harlan also concurs in this case. But he makes a different argument. He says whether or not privacy and the nature of privacy is fundamental is not the issue in this case. Instead, the court must determine whether the law violates our implicit, or it violates the values implicit in our concept of ordered liberty. And since it does, since the very idea of this, of the state coming into marital bedrooms is so repugnant that clearly it's unconstitutional. And Justice Harlan cites Calder v. Bull, that case we discussed earlier, about this idea of the notion that the Constitution has to protect some rights that aren't explicitly in it because those rights are still repugnant to us. There do exist some dissents, and the dissents make a very valid point. So Justice Black is in dissent. Justice Black, allow me to say, it is a rare entity among justices of the United States Supreme Court. Justice Black actually believes that the Constitution means what it says as written. And that's to say that Justice Black is a strict constructionist. Many jurists over the years have claimed themselves to be strict constructionists. And usually when they do that, they fall consistently almost every time on the conservative side of cases. Justice Black was a strict constructionist who really was a strict constructionist. As an example, Justice Black, if you think way back to the beginning of this class, we were doing First Amendment rights. Justice Black was the individual who made the argument that because the Constitution says Congress shall make no law abridging the freedom of speech, that seems very explicit, and Congress can make no law, none whatsoever, abridging the freedom of speech. So he's very strict about his interpretation of the Constitution. Well, in his dissent, he is similarly strict about his interpretation. And he says that the law, by its very nature, is absolutely offensive. And it does violate our sort of notions of understanding of what liberty are. But privacy is nowhere in the Constitution. It simply does not exist. The explicit notion that privacy is what protects a state, or what protects individuals from the state banning contraceptives, is so outside the realm of understanding of what is explicitly in the Constitution that the law in question, while repugnant and offensive, does not violate the Constitution, because the Constitution simply does not mention a right to privacy that is this large and holistic. Justice Stewart similarly dissents and says that the court must view issues of personal rights in the same way that courts view issues of economic rights, which is to say, leave it to the legislatures. His argument here is somewhat persuasive. He's basically saying that, hey, about 30 years ago, the court decided that they were going to stop meddling around using substantive due process in the area of economic rights. That was a really good decision. You should similarly stop mucking around in the area of personal rights using substantive due process. That if you want to invoke these large holistic rights that are very difficult to overturn, just stop doing it and let the legislatures do it. The legislatures, who are regularly elected, directly connected to the people, who can be checked while in office, they're the individuals that should be ushering in or making laws involving new rights. It's not our job, because it's very difficult for us to be checked in that process. And so despite the fact that there are some strong dissents, this is the case where the court fully articulates, they've been hinting at it over time, but this is the case where the court fully articulates a fundamental right of privacy that is broad enough to extend to contraception in the confines of our homes, in the confines of a marital bedroom. Now, that is a very large conception of privacy. And this is the case that gives us that understanding of what privacy is and how large it is. And it only gives us one little notion of what that right contains. But we're going to see over time how the right to contraception gets extended, perhaps even in ways that the majority in Griswold wouldn't have intended.